Mark Furman, Mark of Tarlow, Breed, Hart, and Rogers. Mark, how are you today?
I'm great, Jonathan. Nice to be with you.
Good to be with you as always.
So, wanted to talk about a case that was decided by the First Circuit Court of Appeals in Boston. It came out of Rhode Island. We recently talked about what it takes in order to get a preliminary injunction. And in general, you have to show likelihood of success, that you'll suffer irreparable harm if an injunction isn't granted, no adequate remedy at law, and that the harm to you outweighs any harm to the defendant. So in this case, the plaintiffs were some Rhode Island mortgagors, borrowers, who were in default of their mortgages on Rhode Island real estate. And they brought suit to prevent foreclosure or eviction on the ground that the assignments of their mortgages, legal titles, are invalid, leaving the assignees with no right to foreclose. This relates to a company called MERS, is the shorthand, but its official name is Mortgage Electronic Registration System, Inc. And what would happen is sort of an increasing practice over the last 5 to 10 years was banks, when they would give a mortgage, they were constantly then selling groups of mortgages.
Right.
And
Packaging and bundling.
Packaging and bundling. So for convenience, the mortgage was put in the name of Mortgage Electronic Registration System, Inc. And we've talked in the past about situations where the paperwork, not all the paperwork got done, or not all the paperwork got done on a timely basis, so that these various assignments were not adequately documented. And so, as a result, throughout the country, there were situations where banks, mortgagees trying to foreclose, were unable to prove that they held the mortgage because